Welcome to the Legal Services Clinic of the Puerto Rican Community's continuing series on continuing education for lawyers and, of course, to the general community at large. My name is Anthony Suarez. I'm President and Chair of the Puerto Rican Legal Services Clinic, former state legislator, a professor of law, and, of course, your host here today. Today's course is lobbying the legislature. Let me read you the course description. The representative government requires public accessibility to ensure its accountability and integrity. Accessibility includes the right of the people to petition their legislators for redress of problems. This right to petition enjoys protection against formal limitations under the First Amendment of the United States Constitution. In consideration of legislation by committee or full legislature, legislators set up rules and laws on the proper functioning of this process. Many communications occur at informal forums and at meetings. This class examines accessibility to the legislative process, the limits of political expression and petitioning government, the notice requirements and opening meeting laws. Lobbying is vital to the legislative process. Without the efforts of lobbyists, many significant problems would remain unaddressed. Today, our guest speaker is the Honorable Bob Cortes. Bob was elected to the Longwood City Commission in 2009 and was elected deputy mayor in 2010. He became the mayor of the city of Longwood in 2014, becoming the first Hispanic of Puerto Rican descent to be elected mayor of Seminole County, in Seminole County. Bob was elected to the Florida House of Representatives in 2014 and re-elected in 2016. During his term in office, Bob served as the Vice Chair of the Education Committee, Vice Chair of Transportation. He was also the Deputy Majority Whip from 2016 to 2018. Bob is currently the Senior Administrator for Community Affairs at Seminole County Sheriff's Office since 2019. And so with me, Bob, thank you for joining us.
Thank you, Tony. Thank you for having me.
Bob, lobbying often has sort of a negative connotation, and in this particular class, I want to cover the following: the function of the lobbyist, who is a function, who can lobby, what is their job, gaining access, how do they gain access to the legislative process, the regulations of lobbying, lobbyist disclosures, registrations of lobbyists, reports, the public service, and lawyers as lobbyists, and notice of legislative activity. How that gets done. And then, of course, there's political caucus exceptions. We'll talk about that as well. And ethical questions and on questions of lobbying. And we'll have a lot to cover. It'll be a fun agenda, I know, because it's a lot of fun. Yes. Yeah. And so, Bob, once again, thanks for joining us, because you've been on both sides. You've been a legislator, you've been a city, and well, people don't know, as a mayor and a city council, you will become a lobbyist too, because you go to Tallahassee to lobby for funding for your councils. You've been a lobbyist, you've been a legislator, and of course a local city commissioner, and of course now in your current position, you advise the Seminole County Sheriff's Office on issues that affect the state legislature. In that case, you go to Tallahassee as well. So you have a vast experience in this area of law. So let's talk about first, because lobbyists do have sometimes a negative connotation, but you and I know that without lobbyists, it doesn't work. The system will not work. So let's talk about that.
Well, and first of all, let's make this clear distinction that lobbying does not mean advocating. There's a clear difference between advocating for a particular issue. You, as an individual, can advocate all you want as an individual, as a person, to your elected officials. And that is not considered lobbying. But lobbying is addressed in several statutes in the legislature, particularly for the legislature, for the Senate and the House. It's covered under statute 11.045, It establishes regulations for lobbying before the legislature, including the registration and reporting requirements for lobbyists and lobbying firms. So to give you an example, NASCAR drivers and their teams, they all have sponsored, and on the side of the cars, they all have stickers of who's sponsoring them. And if that and an elected official had to follow that same rule, of course, their jackets would be full of all these stickers of different principles. And I mentioned principles because that's how the law addresses who they work for. A principal is defined in Florida Statute 112 as basically an organization or somebody that pays somebody else to lobby, basically, that has an interest going to the legislature. You know, and you have thousands of principals that go to the legislature each year in the governor's office, executive branch, to bring their issues forward. You know, from healthcare, you know, Advent Health, Orlando Health, all these that are on the healthcare monsters here in Florida, obviously are large principals that go and have their lobbying represent them. So it is a crucial piece of the legislative process, in my opinion. Why? Because many legislators, when they first get elected, are not experienced in all forms and things of government. They're not healthcare professionals. They're not doctors. They may be a lawyer. They may be a business owner. And when you have somebody that doesn't understand environmental issues, or doesn't understand healthcare issues, or doesn't understand transportation issues, you rely on the lobbyists of these principles to be able to educate you on the issue itself. And therefore, under statute, they pretty much establish what the definition of lobbying is. So under Florida Statute 112.3215, it basically has the definitions for lobbyists. For example, and F, it says lobbies means seeking on behalf of another person to influence an agency, in this case also the legislature, with respect to a decision of the agency or the legislature in the area of policy or procurement, or an attempt to attain the goodwill of an agency official or employee. Lobbies also means influencing and attempting to influence on behalf of another the Constitution Revision Commission's action or non-action through oral or written communication, or attempt to obtain the goodwill of a member or employee of the Constitution Revision Commission. So that, it defines in statute what lobbies is. What is the action of lobby is. It also defines lobbyists, and this is very important because I mentioned advocating versus lobbying. It says lobbyist means a person who is employed and receives payment. I'll repeat that. Who is employed and receives payment, or who contracts for economic consideration for the purpose of lobbying, or a person who is principally employed for government affairs by another person or government entity to lobby on behalf of that other person or government entity. Lobbyist does not include a person who is an attorney or any person who represents a client in a judicial proceeding or in a formal administrative proceeding conducted pursuant to Chapter 120 or any other formal hearing before an agency, board, commission, or authority of the state. An employee of an agency or of a legislative or judicial branch entity acting in the normal course of his or her duties. A confidential informant who is providing or wishes to provide confidential information to be used for law enforcement purposes, or for a person who lobbies to procure a contract pursuant to Chapter 287, which contract is less than the threshold for Category 1 as provided in 287.017. Basically, those are the definition and the exemptions provided in Florida statute.
But that's not to mean that an attorney is cannot be a lobbyist.
Correct.
It says if you're practicing as an attorney on behalf of a client before the state legislature or an agency, that is not lobbying. You're acting as a lawyer. If, however, you're getting paid to purport a particular piece of legislation, then yeah, you cross the line. So that's important because lawyers have a special role and they have an exemption, but they also have ethical considerations that actually other lobbyists don't.
And that's a great point. Yeah, obviously, if you are trying to influence the legislature or the executive branch. The key word is influence, and you're getting paid for that, trying to influence, then you are required to register as a lobbyist under Florida law. And in my case, for example, I have two different roles that I carry. I am employed by the Seminole County Sheriff's Office, and my title is Senior Administrator for Government Affairs. And it says very clearly, or a person who is principally employed for government affairs by another person or governmental entity. So as an employee of the Sheriff's who gets paid, and my title is Government Affairs, I am required to register for that agency as a lobbyist. However, I'm also the board chair of trustees for Seminole State College, which I do not receive compensation from the college whatsoever. As acting as a board appointed official, I am not required to register as a lobbyist before the college, before the legislature, to advocate for the college, because that is part of the exemption, because I don't receive payment, and that also is considered part of an agency of the state, an employee of an agency or legislative or judicial branch, acting in the normal course of his or her duties. So as I am required to go to the legislature on behalf of the college to advocate, then there I'm not required to do. However, it has been said if I get paid anything, and this is where the economic consideration comes into place. It's not just being paid a salary. If they pay you per diem or travel or anything else, that can be considered economic consideration. So therefore, you got to watch what you get and how you get it for that purpose. So, so where do we register? If you believe that you fall under that consideration of registering to lobby, how do I do this? What is the process? It's spelled out also on the website in Florida. It's www.floridalobbyist.gov. It's the actual website that has the process of where to lobby, or where to register to lobby for that matter. And there is a fee, and you also have to fill out this application that they will give you, and the principal who is authorizing you to lobby for them has to agree. They will send them also a notification saying, are you allowing this person to lobby for your behalf, and they have to agree. So it's a process that is spelled out, and they have plenty of videos in this website if you have any questions. They also have a frequently asked question portion in the website that answers a lot of that. For example, who is required to register in order to lobby? It says lobbyists who lobby either chamber of the Florida Legislature or the Public Service Commission nominating council must register. A lobbyist is anyone who lobbies for compensation, or any person who is principally employed for governmental affairs by another person or governmental entity to lobby on behalf of another person or a government entity. So it spells it out on the frequently asked, and you must register for each individual principal that is hiring you to do this. For example, if Orlando Health hires you to lobby, and then Duke Energy also hires you, and then OUC hires you, you have to fill out, you're already registered in that, but you have to tie each individual principal that you're authorized, because that way when somebody looks to see who are your clients, basically, it is all part of the public record, and you must register to lobby in that portion of that.
All right, so those are some things. You got the website, you got the statutes telling you when you can. And this is important because I am urging particularly young lawyers who are thinking about influencing in making a difference in the world. Lobbying is one of them. If you can actually get yourself engaged, either, and we'll discuss how you find clients, but there are lobbying firms in Washington, and in, of course, in Tallahassee, here in Florida, and every state capital, there are lobbyists, and they're called lobbyists because they hang out in the lobby. You know? So, and on some issues, there are as many as 3 or 4 lobbyists per legislator on the issue. it becomes a rather large business. As lawyers, those of you who are lawyers who are watching this, you have additional ethical considerations. Bob just mentioned the question having Duke Energy and having Advent Health. You can, a lobbyist can have that. But if you're a lawyer and those two clients have a conflict of interest, you may find yourself with ethical consideration where you're lobbying for someone and it actually hurts the business interest of another client. Mm-hmm. So you've got to be very careful that other lobbyists don't have that situation. But let's go into the interesting part is how do you go about gaining access to the legislative decision-making process? Because most people have no idea. They read about legislation in the newspaper. They don't know how it happens and how you actually make it happen. So let's talk about how these lobbyists used to get at you, talk to you when you were a legislator.
Well, and obviously, it all goes by on the issue. It depends on what committee the legislator serves on, or committees, for that matter, that have an interest for each particular lobbyist or principal. But it also has whatever bills you're filing that may be of interest for that lobbyist or principal to support or oppose. Now, the Florida House, in their rulemaking, has set specific rules on how a lobbyist who is registered to lobby, excuse me, can start doing that. And it's spelled out in their in the House rules. Before, in Rule 17.1 of the Florida House, basically says that if you're going to approach a member of the Florida House on the part of the legislature to lobby on behalf of an issue, you must disclose that through their website. Their website is myfloridahouse.gov, and it has a little tab that says lobbyist disclosure. And I'll give you an example. I get into the elevator, and here comes this lobbyist and gets into the elevator, and he says, Representative, I'd like to talk to you about your House Bill 235. And right now, before I can talk to him, my first question to him is going to be, did you register and disclose that you're going to come to me about this issue in the website? If the person says, no, I have not, under the rule, the House rule, I would have to stop him right there. Says, before you talk to me, make sure you're duly registered with the Florida House before I can talk to you. And therefore, I'm giving him clear notice and warning, and he understands that he may be violating the rule. In violation of the rule could bring sanctions under the Rules and Ethics Committee of the Florida House that include also fines. The Senate does not have that, but the Florida House does have a registration. And the executive branch, as long as you're registered, duly registered for the executive branch on the floridalobbyist.gov, you're covered. So yes, the many will come to you, and lobbyists who know this will have duly registered and disclosed the House bill or the issue they're going to come to the member for before they come to the member and discuss that. Now, there's some kind of exceptions. If you just happen to pass them and crossing and something just happened, hey, your bill has this issue. I haven't registered yet, but I just found this out. I just wanted to keep you aware before you go into the chamber or into the committee room that we're going to be speaking that. But as soon as I'm done, I promise you I'm going to file my disclosure. That is allowed under the House rule.
So what you say, they can also make an appointment to see your office, right? Mm-hmm. So if I'm a lobbyist in the construction industry, there's some bill that's going to affect I can make an appointment to see you, correct?
That is correct, and they make the appointment now. Speaker Perez just announced the new changes to the House rule on this, and they're going to be zero tolerance on this. They're going to enforce it very heavily, and they're not just the member, but the member staff. They're going to make sure that they ask the lobbyist or principal the question if they have fully disclosed their issue on the Florida House page.
So that's one way of access. And then the informal ways of access. For example, there are many activities, back when I was a legislator, rules were very flexible, and every lobbyist had breakfast or lunch or someplace where you could go to have breakfast. That was allowed. Today it's not allowed. But you could go to breakfast and you sit down and have breakfast, and they can sit down with you and just informally talk about a bill.
Yeah, absolutely. And by the way, the disclosure is required under the House rule. You only disclose that particular year once per legislative year. So if the bill changes and it gets amended, as long as you're registered under that lobbyist disclosure, then you're covered. And then the other way of lobbying that is not in Tallahassee at the Capitol and does not need disclosure per se is if you do invite a member, or you go to his legislative office, or you go to invite him to coffee, the member cannot accept any gifts from you as a lobbyist, and they know that. So he has to pay for his own coffee. Or if you attend a fundraiser for that member, and many lobbyists obviously will attend fundraisers and donate to the campaigns as long as they're donating in the times that they're allowed. Fundraisers, members cannot fundraise during session. So at the 60-day legislative session, they're prohibited from accepting any contributions. And this next year, starting in March, the 60 days ends from March to May. At that point, their fundraising abilities are completely capped and blocked. So you will see a mad dash leading up to that legislative session beginning of lobbyists raising money for candidates or incumbent members of the legislature to provide fundraising for them. And during the fundraiser, they can come up, and as long as they're not offering a quid pro quo on that, they're not saying, hey, I'm giving you this check, but you've got to vote a certain way, which is obviously against law, they can talk to them about any issues at that time.
We've been heavily on what the law is and what is not, but I'm trying to also appeal to young lawyers to get into this business, but they may feel like, I don't know anybody. How do I go about doing it? How would you suggest that if they were starting to become a lobbyist, what would they do in order to understand or gain access to legislators?
Yeah, I just mentioned the best way to do it. Legislators are constantly fundraising. They run every 2 years, and they have to fundraise in order to be successful. And in my case, I always told anybody who donated to my campaign is that your check is not guaranteeing that I'm going to agree with you on any particular issue. The only thing that this check is that you support me as a candidate and that you will have access to me when you come and ask for any help, assistance, or you have a question or you want to bring forward something from your principal or principals, that you know me on a more personal level. And Representative Suarez here mentioned, as new lawyers, you gain access to the member of the legislature. The best way is bringing them a contribution that at a fundraiser and then following up with them that way. I can tell you every single elected official loves to receive contributions. It's the only way that they're going to get elected. They know that. Your campaigns cost money, and nowadays with the media and everything else, it's costing a lot of money. So to gain access to them, the best way is to go to a fundraiser and then follow up and say, hey, I'd like to talk to you more about this and this client. Now you've opened the door to have a better and close relationship with them as they move forward. Not guaranteed they're going to agree with you on every issue, but at least you have access.
We've been describing mostly the professional lobbyists, but there's other ways of lobbying a legislature, and there's something we call grassroots lobbying. There are many issue-oriented persons who, a young lawyer gets involved in civil rights or environmental rights or children or education, and then they begin to lobby by way of community outreach. Describe how that works.
Yeah, no, it's a great point, is that as members, they come and they all have their strength and they all want to represent their communities well. And they'll have issues that come every now and then in the community. You have maybe a community that's going to have a big environmental problem because there's a big development coming and everything else, and there's a group that is either opposing the development or there's a group that's supporting the development. At that point, you're going to want to tie to those that are expert in the material on both sides and try to work with them together in the grassroots way to try to get that. And lobbyists will want to join you, because if those that are representing the development versus those that are representing the anti-development or the environmental issue will come together and try to educate you on what's best. Most of these issues are local issues, and that way you can put them together with the local county commissioners or city commissioners and making an effort. Once you're in the legislature, you'll find out that a lot of people will open their doors to you and will listen to you. And the grassroots is not just about that. Grassroots, again, goes to the campaigns. A lot of lobbyists during campaign season will actually send their staff, themselves and their staff, to knock on doors for the candidate. And you will see this happen very often. They're not writing a check. They're actually going down and door to door in support of that. I used to do something every year. I used to host a toy drive every Christmas. And I would put outside the Capitol this bin where they can bring toys to donate to people in my community. And I partnered with a radio station, and we would bring toys. They would come and bring toys from their principals and everything else, and it wasn't for me, it was for the issue of the radio station hosting the toy drive. And those things are allowed too, because I was not receiving a personal gain from this. It wasn't from my personal gain, it was as an outreach for my constituency.
So those of you who may not feel that they have access directly to those legislators, but you have local issues that are involved in your neighborhood. For example, education or something that may touches you personally. If you have a focal group, a group of people, and you go to Tallahassee or to Washington with people who are from that person's district, right, from the legislative district, he said, I want to sit down with you, Mr. Suarez, and we're issue by issue. And by the way, I have 15 people who are your constituencies with us. That's going to be a powerful message to the legislator. And so that is one way for you to get involved in getting access to legislators. So it is professional, being hired by an agent that needs for you to a particular bill or something that's pending. You could be a professional, or you could be a grassroots organizer in order to gain access. And then once you learn the process and you start getting paid for that service, you'd have to do the registration work as well. So those are the important things that we wanted to make sure that you understood and got that. Now,
let me just finish up that section with this. There's a simple guide that they use in the legislature. It says, if you propose it, it should be disclosed. Before you discuss it, before it shows up in any draft of a bill or an amendment, long before it's filed in the House. So basically, if the bill is coming from you, if you're giving the members saying, listen, I have this issue with my principal, and I'd like you to file this bill for me. If you propose it, then you're going to be heavily involved in it. You should disclose it, and you should register and disclose it. If others propose, then you disclose by number. And also be careful from over-disclosing. Don't go out there and there's 2,000 bills in the House and disclose on that. That's not allowed under it. Over-disclosure is considered non-disclosure for that matter. The other part is decorum. It's very important that you, as a lobbyist, maintain professional decorum at all times. There are some things that you may not agree with that member or the legislature or the political party or anything else. Never, ever, ever lie to a member. Never, ever, ever lose your cool or shout or in public or private or even fight with a member. That will get you banned from the legislature, from the Capitol, will get you banned from registering to lobby. You will not be able to do that. And the member will not ever allow you to come back in and will not believe you in that principle. You're hurting more the principle than you are yourself. So I stress that because I've had certain instances where I've had to take some lobbyists before the Rules and Ethics Committee to have them sanctioned because of that.
It's a perfect segue to the question that I have for you, Bob, is that many people misunderstand the role of lobbyists. We've discussed how much, not only is it a constitutional right and how important it is, but every legislator gets to Tallahassee or to Washington basically on a major issue that they were mostly concerned around their community. But when you get there, there are 2,000 bills sitting on your desk of which you may know nothing about, right? Without the lobbyists, you would not really know about, right? So that role of the educator, tell us about how you've used that role in order to be a better legislator.
Yeah, when a lobbyist has been hired by a principal, they didn't just hire them because they were the good looking or they dress well or anything else. The lobbyists that they're hiring are usually material experts in certain fields, whether it's in education, whether it's in healthcare, whether it's in transportation. Each individual lobbyist has their strength, has their knowledge, and has their background, and could almost cite, without even looking at a law book, statutes related to that particular area of expertise that they have. So when I'm talking to a lobbyist, I say, listen, I've got this House bill, and I don't know what it does. There's 200 pages and it has to deal with charter schools. Can you walk me through this? This lobbyist, more than likely, since he's a material expert in the field, will tell you, well, Bob, the way it was before was this bill changes it this way, your constituency will benefit this way or will hurt them this way, depending on that. So you can have a better understanding and knowledge of the particular issue. He's kind of, if the artificial intelligence of today's world condensed into a person that has had years and years of experience in a certain subject matter.
Which gets to the point that you earlier made about the credibility of that lobbyist. The lobbyist, if they come to you with a lie, will never be back into your office, right?
Correct.
So the lobbyists are experts in the field that you're not an expert as a legislator, and they have a reputation to protect for their future business, so they're going to tell you the truth in order for you to. And another thing that people don't understand out there is that when you go to the legislature, whether you're a congressman or a state legislator, you have limited staff. Mm-hmm. You cannot become an expert in subject matter.
That's right.
So you really depend on the legislature, on the lobby, correct?
Right, and because of the lobbyist disclosure, you're not just required to disclose for disclosure. The principles are disclosed here. For example, if I have a lobbyist that comes to me about a particular issue or anything else, I will look that lobbyist up and I will see all the other principles that he represents. And most often I find them representing principles in usually an area of expertise. That tells me that that person is an expert in that. And you can also look into the background of the lobbyist. Where did he come from? If this lobbyist at one point was a lawyer that handled labor law, and for many years, that he was maybe a prosecutor or a judge or something like that in the past, then he has experience in that subject matter to move forward. Then on the flip side, let's say you just have somebody that just got out of grad school and has no experience but is registered to lobbyists, and you can't find much on them. You're immediately going to see by talking to them how much reliable their information is going to be when they come to you. So it's important that usually when the staff schedules meetings with lobbyists that come to your office while you're in session, you're only going to give them 15 minutes tops to talk. So in 15 minutes, they have to learn how to say it. They usually come with a one-pager that makes it, simplifies the issue for you to understand, and leaves a lot of information and background behind for you for at a later time that you can come and research it.
All right, let's now switch gears and talk about notice. How do lobbyists know that a particular bill is pending or is before you?
Well, the lobbyists use a lot of tools that are available to them, and in my world, obviously I use some software that will alert me. I can enter an input, and for example, I use a program called Lobby Tools. It's paid for by the Sheriff's Office and Lobby Tools. I enter certain things like keywords like law enforcement and murder, and just certain keywords. Anytime somebody files a bill that affects that particular issue that I'm interested, it will send me an email, or send me a notification that there's a House bill or a Senate bill that's been filed that touches on something that I'm interested in following. Plus, I also look every day on the websites, the Florida Senate or the Florida House, what new bills have been filed. And I read what the bill does. And now with Chat GTP and everything else, other artificial intelligence software, it's actually condensing, in a paragraph versus reading the whole bill, what the bill actually does. So those are the things that I look for, and if it's an issue that I know is going to affect my principal, my agency in a positive or negative way, then I'll flag that, I'll put it in my folder as we speak, and then I will register with the member in the House that I'm going to be interested in coming to talk to them about this, and that way I'm all covered on all sides.
All right, so you got a computer tool called Lobbyist, Lobby Tools, allows you, that knows what's pending. You also, they publish, the legislature bodies publish in their journals, bills that have been filed that are in the first hearing. That's another course. First hearing, or second hearing, and third hearing. That's published as a public records, correct? Now, what about noticing of meetings? Where a lot of deals are made at a meeting before the bill hits the floor. What about that?
So there's going to be 6 committee weeks this legislative session, the first one starting in December. And you can go on myfloridahouse.gov or floridaFLSenate.gov, and they will have a calendar of all the meetings when they're scheduled. Now, the notice for the committees usually come a few days before. That's being amended right now with the new rules that the House is going to pass next Tuesday. Next Tuesday, they have what's called organization session, where they swear in all the new members, they swear in the existing members, and they pick the leaders of each chambers that are going to lead them, and this starts off the process, basically, of the next legislative session. There are changes coming in this legislative session that we're already starting to see, particularly in the realm of information. The Florida House is going to have now what they call a bill analysis portion that's going to be very comprehensive. It's going to have hyperlinks. It's going to have where the bill is at, where the bill is going to in the next committee, what it's doing, what it's not doing. You can go and search on each page by bill number, and it tells you what committee of reference it has, and if it's being agenda for any particular committee from there. It's going to be very robust. There's going to be huge improvements from when Tony was there, which a lot of stuff was handwritten, and you had to pick up the paper versus now everything's going to be laid out online. So it's going to be a lot easier to follow without having the software that I mentioned for just a lay person to go on each website, and it's going to be very workable.
So all your potential lobbyists out there know that there are tools, and Bob has just mentioned it, so you have access to the meetings that are being held discussing the potential even before it hits the floor, right? So you know that that's just another way. Now, there's something called the Florida Sunshine Law, which I know you're familiar with, and that requires local legislators or commissioners, even if they wanted to discuss something, they have to about a potential bill or rule that's before the commission, they must announce the meeting. But there's an exception with state legislature.
Right, so under Chapter 119 covers the Florida Sunshine, and you can look up all the requirements and exemptions that exist under 119. So for example, if you are going to speak at a committee that has been noticed and agended, and you want to speak on behalf of your principal to address the whole body on this particular issue, you have to register or fill out a speaking form. You're required to do that. You can do it online, you can print it out, you can do it there at the Capitol, fill it out, you hand it to the clerk or to the security there, and they'll hand it to the committee chair. And they will call your name, and then you can speak. You usually limited, sometimes up to 3 minutes, but the chairman can give you more time or can give you less. It's up to the chairman on that. All these meetings are required to be held in the sunshine, which means they are required to be held in the public. Publicly noticed is one of the big requirements. They have to, before you have to put it in a newspaper and do a lot of cumbersome stuff. As long as it's on their website now, or put on the particular website, a publicly noticed meeting with the agenda, that suffices the intent of 119. Now, local bodies, city commissions, county commissions, school boards, even volunteer boards that are of governmental entity are required to have all meetings in the sunshine, and their members cannot talk to each other about these things in private. They can face sanctions, they can even face criminal charges for this under 119. However, the legislature is exempt from that. Why? Why did the legislature have this exemption that doesn't exist for local government? Well, 2 reasons why. Local government meets at least once a month continuously for all throughout their term. Sometimes they can meet more. The legislature only meets for 60 days. So they have to do so much work in so little time, and you have potentially 160 members of the House and Senate that have to talk to each other about particular issues to even make it work. So logistically, it's almost impossible to just not discuss these issues in private to do that. However, if more than 2 people are assembling to discuss that, they said that you may have to notice a meeting for that, even in the legislature. You know, what it means is that, let's say you have 10 members of the legislature that want to discuss about House Bill 222, and they're going to be voting on this bill themselves, then if they don't notice it, they can find themselves in trouble with the Rules and Ethics Committee per the House rules. But if it's one-on-one discussion, is exempt from 119.
And you'll notice if you watch television on C-SPAN or whoever watches the local channels, you'll see that often legislators will get up from the desk and walk over to another legislator and say, what did you mean by that? And they're discussing in little caucuses, and the votes are coming up immediately. There would be no time to be noticing these conversations, to have a public meeting so they can have it. It would be impossible, literally, to be able to impose a sunshine law upon the state legislature because of the shortness of the calendar, because the immediacy of how the votes are being taken. And if you watch television, you'll see, and even in the Florida legislature, there's rooms where in the back of the legislative chamber where you can caucus to get together to make decisions. But you're talking about now. Instant, the bill's up, you're going to discuss it.
And you know, let's say you have a 13-member committee that is discussing a particular bill. And that day, they might have a 2-hour meeting scheduled, and they have 14 bills on the agenda. You have a member that, a lot of members will prepare and read the bills, and some of the members are too lazy, they don't read anything. And then they'll come to the meeting not prepared, and they don't understand what the bill does. What the good role of a good member is to sit down with each member of those committee beforehand, individually, and say, hey, I've got House Bill 222 coming before you and your committee. Let me explain to you what this bill does. You might not understand what the bill does because it might be 60 pages and you're not going to read that in a day. So let me explain to you what the bill does and what I'm going to say when I present the bill, and I hope to get your favorable vote. At that time, once the member explains it, it's like, I did not know that. Thanks for coming to me and explaining it to me. Or, you know, I already knew that and you're good. Or, listen, I don't like the bill, I'm going to be voting against it. By then, you already know whether you have the votes or not for this bill to pass. And if you don't have the votes, you as a member have to make a decision to continue bringing this bill forward that may die in that first committee stop, or postpone the bill, don't waste the committee's time, go back and work the issues that those members are opposing, and bring it back in an amended form to hopefully it'll pass the next
And what
one.
I say is that those meetings or those conferences would not be subject to the sunshine law, as opposed, for example, I, as a county commissioner on one of the enforcement boards of Orange County, if I tried to do that same thing with one other member of the Code Enforcement Commission, for example, which I currently serve on, and that would be a violation of law,
Correct.
because I cannot do it that way. All right, Bob, we're coming close. I want to do the last couple of minutes, talk about ethical considerations, particularly those ethical considerations that lawyers may face, or ethical considerations that you have seen in all your roles, the different roles that you've had, both as city commissioner and now with the sheriff's office and of course as the legislator. What are the ethical problems that you see people doing?
Well, first of all, you're dealing with issues that particularly are going to have a potential gain or loss for somebody. Obviously, a lot of things are driven by money. And if it's something that makes you feel uncomfortable, if you believe that you as a person will not be able to sleep well at night on the decisions that you're going to make, then it's probably not the right decision to make. You as a member yourself and as the lobbyist, I would be very hesitant to support something that's going to put a lot more money individually into that lobbyist's pocket. Obviously it's unethical, and it's maybe even criminally, and it may be illegal completely. It might bring him into the court of law and me pretty much also get arrested. So those are the things upon most that they do. But there are other things that you have to. I mentioned, decorum. I mentioned about lying. That you're lying to a member. I'll give you some of the forms of lying. It says, "Hey, I need you to support this bill that is for my principal, and I've already spoken to the Senate President and the Speaker of the House, and they told me they're good with it and that you need to vote on this." And then when you go to the Speaker of the House and the President says, "I haven't talked to this person about that. What are you talking about?" You know that you just caught him in a lie. And at that point, you're going to look at that person and say, you lied to me. "Yeah, I'm sorry. I meant to say I was going to talk to them." I said, no. That's not what you said. You said you had talked to them, and they said to tell me that to vote on it. So, things like that are unethical, but also would get you a swift kick in the butt and says, "You're not allowed in my office anymore."
So, you have the question of fundraising. We discussed it earlier, but you also used the word quid pro quo. Mm-hmm. Talk to them about how this quid pro quo runs the fine line.
Right. It goes, and I mentioned about money before, something that's going to put money in somebody's pocket. And a lot of lobbyists will use the fundraising part to be able to get you to vote or to support or even to file an appropriations request. Remember, the legislature just doesn't deal with policy, but deals with the state budget. And one of the only, I don't know if anybody knew this, but the only requirement constitutionally that the legislature has every year in session is to pass a balanced budget. If they do nothing else, if they pass no other bills, but they pass a balanced budget, constitutionally, that's the only thing that they were required to do. If they don't pass a budget, they have to come back before the fiscal year and meet and pass a budget before they can adjourn. So in that budget means appropriation requests. Let's say some principal says, "I want $1 million to fund let's say an environmental issue that is in my community. And this environmental issue is going to make sure that we have clean water there." They're going to go to the legislature and ask the legislature out of general revenue to fund it. If the lobbyist is using the fundraising ability to come to your fundraiser and say, "I'm going to give you this check, but you better get me $1 million in the budget for that," that is unethical, and that's something that I would just look at the lobbyist and say, "Are you thinking that this is going to buy me to do this? You can have your check back."
And lastly, as a lawyer, you have an ethical consideration that perhaps other lobbyists do not, and that is conflict of interest among your clients when you're lobbying. If you're lobbying, for example, a limitation on bringing in, if it's a federal matter, bringing in auto parts from out of state, or out of the country, and you also represent a manufacturer of vehicles, you may be pushing for one is against the interest of another. This could happen in various ways, depending on the clients that you have as a lawyer. You must be considerate of these potential conflicts, which may not be resolved even with disclosure. Of course, with a disclosure, if you tell one client, listen, I'm pushing for an environmental protection, and that's going to hurt your ability to build along the Econ River, that's a conflict. But if they disclose it and you find and they're okay with it, you might be able to justify it. But I don't know if you have a client at the end of the session. But those are considerations.
And for us on the legislative side, we'll look at that. And if this lobbyist comes to me and one day he says, well, I'm lobbying here on behalf of the auto parts that are bringing from out of state. And then the next day he said, I supported that yesterday, but today I'm going to oppose it because you're going to look at him and you're going to say, wait, what? That doesn't make sense. The way lobbyists deal with that I've seen them in the past deal with that, is one, they disclose it to their principal, first of all. And they'll pick one or none to represent. At that point, they say, I've got a conflict. And they usually pass it on to other lobbyists, because usually big principals will have not just one main general lobbyist, they will have several. And this is easily, when you go into the Florida lobbyist disclosure, when you see a principal, especially a large one, you usually will see different lobbying firms. So how they can get out of the conflict is that you may have your lobbying firm that represents the auto parts, but then you pass on your client, that is the autos, to a different lobbying firm. Now it's not unethical, and now he can lobby against while you lobby for, and then let the best one win. Now you're representing both of the clients well.
Well, thank you, Bob. Thank you for this, your expertise and your time and your service to the community. I know it's invaluable. I want to thank all of you for joining us and the Legal Services Clinic in our CLE program, and we'll see you for the next one.